Good evening to all distinguished participants. Welcome to day two of the 5-day faculty development program on patent filing process in India. Today's session is titled Step by Step Patent Filing Process, a practical guide from idea to granted patent. In today's session, we will systematically understand how an idea can be transformed into a patent application and subsequently progress towards the grant of a patent. The objective is not merely to understand the terminology, but to develop a practical understanding of the complete patent filing journey. Let us begin with the agenda for today's session. We will first understand the patent filing workflow, beginning with the invention and progressing towards the grant. Next, we will discuss drafting and filing the patent application, including the distinction between provisional and complete specification, important forms, and the fee structure. We will then examine publication, examination, and responding to office actions, including statutory timelines and request for examination and the first examination report. After that, we will discuss grant of the patent and post-grant procedures, including renewal fees, working statements, opposition, and enforcement. Finally, we will look at important practical tips, do's and don'ts, which can help applicants to avoid common mistakes during the patent filing process. Let us get into the main subject directly. Let us first understand what a patent actually means. A patent is an exclusive statutory right granted by the government for an invention that is new, involves an inventive step, and is capable of industrial application. In India, the patent provides the owner with the right to exclude others from making, selling, using, or importing the patented invention for a limited period. The patent term is generally 20 years from the filing date. There are three fundamental criteria of patentability as discussed already in the day one faculty development program. The first one is novelty. The invention must be new and must not have been previously published or publicly known anywhere in the world before filing. The second criterion is inventive step. The invention should involve technical advance and should not be obvious to a person skilled in the relevant field. The third criterion is industrial application. The invention must be capable of being made or used in an industry. Therefore, before investing time and the resources in filing a patent, it is essential to evaluate these three fundamental requirements. Let us now understand the basic fundamentals of patent filing workflow. There are 8 major stages. The first stage is idea and invention disclosure. Second one is patentability search. Third stage, drafting the patent application. Fourth stage, filing the application with the patent office. Fifth one is publication, request for examination, examination and responding to office actions, and finally grant of the patent. Understanding this sequence is extremely important because patent protection is not obtained simply by preparing a document and submitting it. Every stage has its own requirements, procedures, and timelines. Let us now examine each stage in detail in the following slides. As per the patent filing workflow, the first stage is about invention disclosure and patentability search. The first step is to clearly capture and document the invention. The inventor should record the invention through an invention disclosure form. The disclosure should clearly explain the problem being solved, the technical solution proposed, and the advantages over existing methods. It is also important to correctly identify all genuine inventors. When where an invention is developed within an institution, the relevant institutional intellectual property policy and ownership or assignment requirements should also be examined thoroughly. The next activity is the patentability search. A prior art search should be conducted using appropriate patent databases, say, for example, Google Patents and World Intellectual Property Organization. The purpose of this search is to assess whether the invention demonstrates novelty and inventive step. A good patentability search can significantly improve the drafting strategy and help to avoid unnecessary expenditure later during examination. Therefore, remember these basic important principles. A thorough prior art search at the beginning can save significant amount of time and legal cost later. Second stage is drafting the patent application. The second major stage is drafting the patent application. At this stage, one important decision is whether to file a provisional specification or a complete specification. A provisional specification can be filed to secure an yearly priority date when the invention is still under development. At this stage, claims are not mandatory. However, the complete specification must follow within 12 months, otherwise, the application is treated as abandoned. The complete specification is filed when the invention has been sufficiently developed for detailed disclosure. It should contain the full description about the invention, claims, abstract, and drawings wherever applicable. Among these elements, claims are particularly important because they define the legal scope of protection being sought. A well prepared specification normally includes the title, abstract background, and field detailed description, claims, drawings, and the best method of performance. Therefore, patent drafting should not be treated as simply preparing technical documentation. It requires careful consideration of both the technical disclosure and the legal scope of protection. The third step is filing the application with the patent office. Once the application is properly prepared, the next step is filing it with the appropriate patent office. The application may be filed with the appropriate office based on the geographical indicators like Chennai, Mumbai, Delhi, or Kolkata, either in person or through e-filing system. Let us briefly look at some commonly used form for filing the patent application. Form 1 is the applicant for grant of patent. Form 2 relates to provisional or complete specification. Form 3 is associated with the statement and undertaking related to foreign filings. Form 5 concerns the declaration for inventorship. And Form 26 relates to the power of attorney when the application is filed through an external agent. Applicants should also understand the applicable fee structure. Different fee slabs may apply to natural person and startups, small entities and large entities or others. Additional fees may apply for matters such as extra pages, additional claims, priority related requirements, and the patent cooperation treaty related filings. Fee concessions may also apply to eligible categories, including educational institutions. Therefore, correct identification of the applicant category is very important before filing the application. The fourth step is publication of the application. After filing, the next important stage is publication. Under the standard route, the application is automatically published in the official patent journal after 18 months from the filing date as applicable. However, applicants may request yearly publication by filing the prescribed request and paying the applicable fee. Once published, the application becomes available for public inspection. The presentation also highlights the possibility of pre-grant opposition under Section 25 within the prescribed period. It is very important to understand that publication does not mean that the patent has been granted. Publication simply makes the application available for public domain information and inspection. The applicant must still undergo examination before the patent can ultimately be granted. Fifth step is request for examination. Now we come to a very important stage, the request for examination under patent filing process. Publication alone does not automatically trigger examination. The applicant or an eligible third party as applicable must actively request examination. Form 18 is used for requesting examination, while Form 18A is associated with expedited examination for eligible applicants. The presentation highlights a 48-month period for filing the request, calculated from the relevant priority or filing date as applicable. An expedited examination route is available for eligible categories such as startups, small entities, women applicants, and certain other specified categories. One of the most important practical lessons here is to carefully monitor the deadline. If the request for examination is not filed within the applicable period, the application is treated as withdrawn. Therefore, maintaining a proper patent docket and the deadline tracking system is essential. The sixth step is examination and responding to office actions. Once examination begins, the examiner reviews the application, including its claims and a disclosure, particularly in relation to a prior art and applicable requirements. The applicant may receive first examination report. The first examination report identifies objections or requirements that need to be addressed. The applicant must respond within prescribed period, which the presentation identifies as typically 6 months, subject to applicable extension provisions. In some cases, a hearing may also require to resolve outstanding objections. When responding to first examination report, each objection should be addressed carefully and point by point. Issues may relate to novelty, inventive step, clarity, or prior art references. Claims may need to be amended where necessary. However, amendments cannot introduce new matter beyond the original disclosure. Arguments and the supporting evidence, including technical advantages or experimental data, where appropriate, may help to distinguish the invention from cited prior art. Above all, applicants must carefully monitor the response deadlines. Failure to respond within the applicable period can result in the application being treated as abandoned. The seventh stage is grant of patent and post-grant procedures. After the objections have been satisfactorily resolved, the application can proceed towards final grant. Once granted, the patent is sealed and published in the Patent Office Journal, and the applicant becomes the patentee. However, the responsibilities of the patentee do not end with the grant of the patent. There are several important post-grant responsibilities. First is renewal of the patent. Renewal fees are payable annually from the third year onwards to maintain the patent for the full term. Second is working statement, which is associated with Form 27 and provides information concerning the working of the invention in India. The third is post-grant opposition. The presentation highlights the possibility of opposition within 1 year from the publication of the grant under Section 25 of 2. Finally, there is enforcement. A patentee can take appropriate action against unauthorized use or infringement of the patented invention. Therefore, obtaining the patent is not the end of the intellectual property journey. Effective maintenance, monitoring, and enforcement are also very important. Here are some practical tips, do's and don'ts while filing the patent application. Let us now consider some practical recommendations. First, document the invention properly and conduct a prior art search before beginning the drafting process. Second, maintain confidentiality and avoid public disclosure before filing. The third, draft claims that are sufficiently broad to provide meaningful protection while remaining specific and supportable. Fourth, maintain a proper system for tracking every statutory deadline, including examination request, first examination report responses, and renewal fees. For complex patent specifications, it is advisable to seek professional assistance from a registered patent agent. Now let us look at some important things to avoid. Do not publish, present, or commercially sell the invention before filing without understanding the implications. Do not simply copy claim language from unrelated patents. Do not ignore or unnecessarily delay a response to a first examination report. Do not assume that publication means the patent has already been granted. And finally, do not forget renewal fees because failure to maintain the patent can result in loss of protection. These practical habits can make a significant difference between a smooth patent filing process and an unsuccessful one. At the conclusion of today's session, participants should have a clear understanding of the complete patent filing journey from invention to grant. They should also develop practical knowledge for more effective drafting and filing. Another important outcome is awareness of the legal and procedural requirements applicable at different stages. Ultimately, this knowledge should improve the participants' ability to protect innovations and explore their potential for commercialization. The central message of today's session can therefore be summarized in three words: innovate, protect, and commercialize. With this, we come to the conclusion of day two of faculty development program on patent filing in India. I hope today's session has provided you with a structured and practical understanding of the patent filing process, from identifying and documenting an invention, conducting a patentability search, drafting and filing the application, through publication, examination, responding to objections, and finally obtaining and maintaining the patent. I encourage all participants to apply this knowledge carefully in their academic research and innovation activities. Thank you very much for your valuable participation and attention. And I wish you all the very best in your research, innovation, and intellectual property journey. We will meet in the day three faculty development program on intellectual property rights. Thank you all.